I'm about to share a very surreal and unsettling story about how the government of Nova Scotia, Canada, to cover their butts in connection with a data breach, was able to get my personal information from a website that I use daily, and then they got an unprecedented court order requiring my internet service provider to hand over my contact information. Hi, my name is David Fraser. I'm a privacy, internet, and technology lawyer with the Canadian law firm McGuinness Cooper. I also teach internet and media law at the Schulich School of Law at Dalhousie University. In this channel, I try to provide educational and informative content about Canadian privacy and technology law. This is mainly going to be a first-hand account of an unsettling experience I had a few years ago. You're probably familiar with the Canadian Legal Information Institute, or CanLII. It's an online service that's largely funded by the Federation of Law Societies of Canada. It's the largest repository of free legal information in Canada, with one of the most comprehensive and up-to-date databases of legal decisions, statutes, and regulations. I use it on a daily basis. CanLII contains decisions from most, if not all, courts in Canada, and from many administrative tribunals. One of them is the Nova Scotia Workers' Compensation Appeals Tribunal, or WCAT. All the decisions provided by WCAT to CanLII are redacted to remove the names of the employees and the employers in order to protect the privacy of the individuals. As I understand it, until 2020, all of the decisions of WCAT from before 2010 were not on CanLII. But they were on a web server maintained by the government of Nova Scotia. They were posted in a redacted form. The government was going to retire their website and move all the pre-2010 decisions to CanLII. As a result of a significant screw-up, the Nova Scotia government sent CanLII unredacted versions of those decisions, and the unredacted versions ended up on the CanLII database for a number of days in May 2020. Apparently, the website the government operated redacted the records in real time, so the underlying database was unredacted. Nobody clued into this when they sent the entire database to CanLII. They just assumed it was all redacted, and no real diligence was done given the nature of the information. Those decisions included very personal employee information about family members, sexual abuse, and mental health issues, including one man's thought of killing his coworkers. On May 12, 2020, I was contacted by Yvonne Colbert, a CBC reporter whose beat included privacy and consumer protection issues. A member of the public had contacted her to let her know that unredacted decisions from WCAT were available on CanLII, and she reached out to me for a comment. I went on the CanLII website and poked around the database to confirm for myself that unredacted decisions were indeed available. Yvonne reported her story the next day, and in the meantime, the government reached out to CanLII and had these decisions removed from public view on the site. About a week later, I was contacted by email by a person at WCAT who saw from Yvonne's reporting that I had read some of the decisions. The email said, quote, "As part of our response protocol to a privacy breach, we are reaching out to identifiable people who may have accessed or downloaded the material to request that they immediately destroy it and not share it further. In the event you retain in some manner this information, please confirm by return email that you have destroyed or will immediately destroy any and all information that you may have downloaded and or screenshot and or printed with respect to the above in order to protect the privacy of individuals." This didn't seem to me to be unreasonable, and I was happy to confirm that I had not kept or recorded any information about the cases I looked at. It was clear from the CBC report that I had indeed looked at some of the unredacted decisions. Now, I'd largely forgotten about this incident until April 2021, almost a year later, when I got a phone call on my home number, which I almost never give out. The caller ID said Government of Nova Scotia. The person at the other end of the line told me that they are investigating the WCAT privacy breach and that they had obtained my contact information pursuant to a production order. They wanted to know what I had accessed or saved. I told them to communicate with me in writing, which they did. Now, frankly, I was flabbergasted and puzzled about how they would have gotten such an order unless I was suspected of wrongdoing. This was very reminiscent of another Nova Scotia privacy debacle that got international headlines. In 2018, the government of Nova Scotia posted hundreds of documents containing some of the most sensitive information about hundreds of citizens online and discovered that some of them had been accessed. They imagined that some super hacker had cracked their Tinkertoy system, called the cops, got a warrant looking for this super hacker, and 14 cops raided the house of a teenager. I'm lucky I got a phone call and not 14 cops raiding my house. All of it was surreal. I wanted to know what had happened and why. And so here's what I know. When the government of Nova Scotia discovered their massive screw-up, they wanted to identify who may have accessed the records, just like in the 2018 case. Remember, these were records that they made public, and there's nothing criminal about accessing public information on the internet. In the 2018 case, the government already had the logs of the servers because they controlled them, which included the IP addresses of those who may have accessed the records. But in this case, only CanLII had those logs. So the government asked CanLII for the logs of who had accessed the pre-2010 WCAT decisions on the site. And CanLII just handed it over. No court order requested or required. CanLII has since told me that they thought the government just wanted to know how many people may have accessed the records. And CanLII was never told that the government would attempt to identify those people. They also thought, very incorrectly, that IP addresses are not personal information. But more about that later. So with these logs in hand, which were pretty detailed, the government went to court in October 2020 to try to require the relevant internet service providers to hand over the customer names and addresses associated with the IP addresses that they'd obtained from CanLII. Now this is 4 months later. It's unclear to me what was going on in the meantime. What I do know is that they went to the court to get information from at least 2 internet service providers, Bell and Eastlink. From the court file, it's clear that the government first asked for the records without a court order, and to their credit, both ISPs said come back with a warrant. Personally, I think they should have resisted the applications in court. The brief that they filed says that WCAT wanted to contact people who had accessed the records to ensure that nothing had been retained or further disseminated. Quote, the WCAT is taking steps to contain any privacy issues that may have resulted from the posting of the decisions. This includes attempting to determine who accessed decisions while they were available on CanLII so that the WCAT can contact those individuals and ask them to confirm that they did not retain or disseminate copies of the decisions or any potentially identifying personal information therein, or that they have destroyed any such copies or information. Requiring the respondent to provide the WCAT with the requested information regarding the IP addresses will assist the WCAT in taking these steps. So they made 2 applications in court for what is essentially a Norwich order. Norwich orders are named after an English case called Norwich Pharmacol, in which a drug company sought to identify the importer of drugs that it said violated its patents, and customs officials were unwilling to provide the records related to import without a court order. So in Norwich Pharmacol, the British House of Lords held that where an innocent third party has information relating to unlawful conduct, a court could compel them to assist the person suffering damage by giving them that information. These orders are actually commonly used in Canada to identify alleged bad guys in connection with defamation, cyberbullying, and copyright infringement. I have never heard of an order like this being issued to get information about an entirely innocent person to further a damage mitigation exercise. Norwich orders are equitable and discretionary orders. Whether a court should issue such an order requires the consideration of 5 factors. And I find it a little ironic that the authority for this cited by the government is a Nova Scotia case that I was involved in. But in any event, the 5 factors are: 1, whether the applicant has provided evidence sufficient to raise a valid, bona fide, or reasonable claim. 2, whether the applicant has established a relationship with the third party from whom the information is sought, such that it establishes that the third party is somehow involved in the acts complained of. 3, whether the third party is the only practicable source of the information available. 4, whether the third party can be indemnified for costs to which the third party may be exposed because of the disclosure. And finally, 5, whether the interests of justice favor obtaining the disclosure. In this case, there was no possible or conceivable legal claim to be made against the third party, and the third party in this case is me. The government said that the first factor is not relevant in this particular case. Here's what they said in their brief. The WCAT submits that the first factor outlined above is not relevant on the facts of this case. Unlike the applicants in Olson and Facebook, the WCAT is not seeking this order so that it can sue in defamation or bring a similar claim for damages. Rather, the WCAT is trying to determine who accessed the unredacted pre-2010 decisions while they were posted to CanLII's website so that they can take steps to try to contain any privacy issues that may have resulted from this inadvertent disclosure. The inapplicability of the first factor outlined above should not affect the outcome of this application. As Justice Wood noted at paragraph 4 of Olson, orders of this nature are discretionary, flexible, and ultimately equitable remedies. Accordingly, it is appropriate to adjust the factors enumerated in Olson as required by the circumstances of a particular case." Unquote. So they put all the emphasis on the last factor, whether the interests of justice favor obtaining the disclosure. Then they argued that they were trying to further the objectives of the Freedom of Information Protection or Privacy Act to protect the privacy of the people named in the WCAT decisions. Notably, they said nothing, not a single word about the privacy interests of the individuals whose information they were seeking. There was no reference to the Spencer decision from the Supreme Court of Canada that found that there's a charter-protected right to anonymity online. As I understand it, in the previous application before a different judge, that judge required that WCAT include the following limitations in the granted order. At paragraph 2, the WCAT shall use the information for the sole purpose of trying to contact the persons who access the unredacted WCAT decisions posted to the website of the Canadian Legal Information Institute between May 7 and May 12 to confirm that those persons have not retained or disseminated any of the decisions or any information therein that should have been redacted before they were posted to the CanLII website. Paragraph 3 says the WCAT shall not use the information for any other purpose and will keep the information private and confidential and not share it with any other person or entity. Now, this is a small but important measure to protect against misuse of personal information. It also wouldn't have permitted them to swat me. So here's the recap. In 2020, the government of Nova Scotia once again made the sensitive personal information of hundreds of people publicly available on the internet through their own incompetence or lack of diligence. They sought information about who had accessed the data so that they can mitigate some of the damage. Importantly, there is nothing unlawful about looking at data that is publicly available on the internet. They got log file information from CanLII without a warrant or a court order, and then got an unprecedented court order requiring internet service providers to identify the people who had those IP addresses so they could contact them to demand that they account for their lawful activities. If I'd wanted to print all those cases and save them, there would have been nothing to prevent me in law from doing so. So I've had a chance to reflect on this, and I still have questions. Now, pretty quickly I contacted CanLII with a big WTF. Now, I admire CanLII. I appreciate the work they do and how much it has moved access to justice in this country. I was very polite but extremely perturbed that they would just hand over this data to a government agency. I use CanLII daily for legal research in order to provide advice to my clients. What I am searching for on behalf of my client, what I am reading on behalf of my client, is incredibly sensitive and confidential. It's protected by legal advisor privilege, and CanLII's actions did not at all reflect the importance of safeguarding this type of information and the trust that we should have in them to keep this information confidential. I was equal parts mad and sad. When I reached out to them, they were very responsive. They said their understanding from the province was that the province would use the IP addresses to understand how many people accessed the decisions. They did not know that the province was then going to try to identify the individuals. They did not get notice of the Norwich order, for example. They told me this is the only time that CanLII has provided user log data with IP addresses to a third party. CanLII told me, and I quote, "This is the only time that CanLII has provided user log data with IP addresses to a third party. While IP addresses on their own do not convey information about identifiable individuals, the outcome of this matter illustrates how they can be personal information and, as you point out, sensitive personal information that can lead to the disclosure of client confidences. While we are not suggesting any wrongdoing, we are surprised that the province proceeded to court without letting us know, and surprised by the court's willingness to issue a Norwich order." So I'm confident CanLII will not do this again. So what about the government's actions in this? Obviously, they should be much more competent when it comes to protecting personal information. This incident never should have arisen. I don't think it was appropriate for the government to seek this sort of information related to people who did nothing wrong. I understand wanting to know about the scope of access to the records, but that could have been easily answered by asking CanLII how many unique IP addresses were in their logs and how many records they relate to. I'm pretty adept and used to dealing with the government, but I don't know how many other people got phone calls from the Nova Scotia government implying they'd done something wrong. And nobody would have known about this if they hadn't called me. Frankly, I'm surprised that they bothered to call me after I'd already told them that I didn't keep any copies when they first contacted me after the first news report was published. It is a reminder that Norwich orders are equitable and discretionary. If you can convince a judge that it's in the interest of justice, apparently you can get one. The bar for doing so has apparently dropped considerably. I do note that because they are made ex parte, the government would have a duty of candor. And the lack of any discussion about my privacy in their submission stinks. In my opinion, the court should have appointed an amicus to make sure that all sides of this extraordinary issue were examined. To my knowledge, there was no written decision of either of the judges, just 2 orders, one against Bell and one against Eastlink. I'll share all the documents I have with links below. I hope this has been interesting. I try to put out a new video each week or so if you're interested in this sort of content, please click the like and subscribe buttons. Also, leave a comment if you have any questions or if you have any suggestions for other topics to cover. And of course, feel free to share this with anyone who you think may be interested in hearing about developments in Canadian tech and privacy law. Thanks for tuning in.